All right, we are recording. And let me get set to where, there we go. It's another KPI Cafe, and I'm excited here because I have Tom Kline here to talk to me about liability, right? What a sexy, exciting topic. But before we get into that, Tom, what's your origin story? How did you wind up to where you are right now? How'd you get in automotive, and how'd you get to what you're doing today?
Hi, thanks for having me, Dane. So my family has been in the car business since 1925. I'm actually a third generation car guy, so I guess it's technically in my DNA. I started at a family-owned dealership about 30 years ago, and that dealership sold recently, and so now I'm no longer a dealership owner, but I'm out helping dealers. But my family's been in the business, that's almost 100 years, and how old's the country? 200 and odd. So like 30% of the life of the country, we've been in the car business.
That's great. I kind of making lines like, oh, it's such a sexy topic, but it's an important topic. I mean, there's serious consequences for dealers not being compliant. There are major things that they need to be aware of that I think really warrants a conversation. And that's why I wanted to bring you on to really dive into that, because I tell you what, like I said before we started recording, I've not heard of anyone that does this but you. And the materials you sent over, clearly you know what you're talking about. So I'm excited for this conversation today.
Great. It's good to be here.
I recently had read an article of yours. I think it was called Lollipop One. And in it, you tell a story about shopping for a vehicle, and you found an ad that listed for a certain amount per month. But when you contacted the dealer, you were told there wasn't one available, but there was a base model for like the same price. And at one point, I think you called the GM son, and he called back. He alleged he'd spoken to a lawyer. So there are a few things that bother me here. First, referring to a conversation with a lawyer sounds like a red flag, that either they knew what they were doing or they're negligent of it, and then they were like really defensive about it. Like what was his intent? Do you think he was trying to intimidate you? Like what do you think his intent was by saying, well, I talked to my lawyers? What's up with that?
Well, the process started when I identified the car that we were looking at, my fiance and I called up and I identified myself as an automotive compliance consultant. And I was very clear about it. And I said, we'd like to lease, it was a lease, we'd like to lease this car for $679 a month by 36 months. I think it was $5,500 down. And is it available? And she'll check on it, and she didn't get back to me, essentially. And I called back and I said, so is it available? And the answer was that I couldn't get the one that I called about, but I could get one, but it wouldn't have the same equipment on it as the one that was advertised. And by the way, they don't have any of those in stock, but we can factory order one for you. So that was the backstory when I called and I said, look, I'm trying to buy a car, and here's what I was told, and is that right? And that's when the owner's son, Austin, as I'm going to call him to protect the guilty, that's when Austin said, I'll get back to you. And he called his lawyer and said, well, this is not a problem because the factory is pushing these prices, so it's not us. So kind of sorry, but not sorry kind of thing. And there's so many violations within that context. It's a little bit laughable, actually.
Yeah, I was really shocked, but I mean, so to clarify, like, let's say in the ad, like, if in the ad, like, you saw the ad and that's what interested you, even if there's a disclaimer that specifically states something like model for $679 per month, not pictured, is that still a liability?
Yeah. So the problem here is whatever the equipment, and I don't remember what the equipment was, but they had listed that equipment and with the price of the $679. And then when I called and I said, I want to get one, they said, oh, well, if you notice in the disclaimer, it's only the base model you can get for $679. I said, that's not what the photos show. The photos show with all the equipment. So one of there are so many problems here, but First problem is you can't show photos of a vehicle, let's say that have upgraded tires is a good example because it's an easy one to pick out, right? If it has upgraded, not tires, but wheels, if it has upgraded wheels, you can't show the picture of the upgraded wheels and disclaim it and say, well, this is 679 is only for the base model. That's deceptive.
Okay. So there's no like disclaimer, there's no language starting at like if you visually depict one thing, that's sort of the end game there for you.
Correct. Now, if you picture the right vehicle and you don't have it in stock, you can say, as an example, you can say 679, and in the disclaimer you can say 679 price available by special order only. Then somebody who's shopping on there says, oh, okay, I can't get this. Dealer doesn't have it in stock, but if I want it, I can special order it. No problem with that. That's not what they did here.
Yeah. Like I said, like you said it, I said it, there are many issues I have with that whole exchange you had. But so here's the thing: is there's so many television commercials, so many Facebook ads, YouTube bumper ads. There's so much visual content out there. How common is it that I mean, you might not have a statistically relevant number, but like, how prevalent is it that dealers are potentially making this mistake of showing the wrong model with the wrong price?
Well, that's, you really have to have the invoice in order to be able to factually say that, right? I'd have to see the invoice on that vehicle and then compare the invoice to the pictures. But I can give you as an example, I have a client, I went on his website and within an hour I found 7 advertising violations. The disclaimer was wrong. There was no, there's a thing called a trigger term, right? If you put a price or a payment, you have to put the rest of the terms. So how much down, what's the length of the financing, what's the annual percentage rate, these all have to be included. So if you put one up, you have to put them all up. And so that's a common mistake. And that goes for whether, for example, on the side of a car, if you walk on the lot, it says you can get this car for $679 a month, and it doesn't have a little tag in the window that says $679 a month times 36 months for a lease with $5,500 down, with approved credit plus taxes, tag, and processing fee, then just to break that down, it's still an advertisement, right? You're advertising $679 a month, even though it's on the side of a car. So you have to put a disclaimer with all of those things. And if you don't, as an example, if you don't put the processing fee plus taxes, tags, and processing fee, then it's assumed from a legal perspective that the processing fee is included. So if you charge the customer a processing fee, that becomes a deceptive act. The deceptive act has problems for 2 reasons, really. Number one, there's something called an attorney fee shifting provision, which means that when you get sued as the dealer, the law says that you have to pay for the consumer's attorney's fees because it comes under an area called the unfair and deceptive acts and practices. So the first thing is there's an attorney fee shifting, which means that when that plaintiff attorney sues you, he's going to get paid by you. And so he doesn't have to get paid by the consumer. So that's a problem. And then there are treble or triple damages if they can show that it was deceptive. So a $50,000 car becomes a $200,000 problem by the time you triple it, add lawyers' fees to it, just for improperly advertising. And I've seen plenty of these kind of lawsuits. They happen. There are usually in a lot of states, I know there are a set of lawyers that do nothing but sue car dealers.
Huh.
That's their stock in trade. They sue car dealers. They understand the laws. They understand how they're broken. And so I know I'm going kind of a long way to your question of, yes, there are a lot of problems when I see automotive advertising. It's seldom that you see them that they're done well. There are very conscientious dealers who try to do it right, but it's hard. It's complicated. And did you leave the disclaimer up long enough, or did you just flash it and take it away, right? Because that could be construed as deceptive. If somebody can't actually read the disclaimer, like, oh, $679 a month, and okay, yeah, I can do all that. If you don't leave it up long enough for them to read, it's considered deceptive.
Huh. Interesting. I did not know that. Now, I like the idea that how you propose it, like advertisement, like the sticker on the car is an advertisement, because I don't think typically most people have that conception that that's still an advertisement. So I like what you covered there. Now, disclaimers. The disclaimer was wrong. What are like some of the biggest or most common violations of disclaimers? Like you're talking about, they didn't leave up the disclaimer long enough. What's like the standard? What it would like? How long does it need to be up? Or what are some of the biggest glaring violations you see with dealerships?
Sure. So first of all, you have to be able to read it. So it can't be in a font size that's so small that a normal, ordinary person couldn't read it. So when it's at the bottom of the screen and you got to get your face right up to the TV in order to read it, that's a problem. If it flashes up, it should be there for 3, 4, 5 seconds, at least enough that you can read it. Now, if it's a whole paragraph, then you can either do it in pieces, right? You could break it up throughout the 30-second commercial. You could leave up each piece for 4 or 5 seconds and do it that way, or leave it up at the end, or have it be big enough that you can actually read it. So that's a big problem. A lot of times the problem also is that it's not English. It's some other language that was come up that somebody came up with that you can't understand. I was talking to a dealer yesterday and went on his website, and I went to the disclaimer and we went sentence by sentence. I said, "What does that mean?" And he said, I don't know. He said, "I guess it was the language that the website provider gave us when we put up the website." So pro tip here is check your disclaimer and make sure it's not the one that the website provider gave you, because it's for certain wrong, because they don't care. They're there to provide a website. They're not there to help you with the disclaimer. All kinds of gibberish and gobbledygook they put up just to plug something in. So first thing is audit yourself. Make sure that you are shopping your own advertising. Have somebody do it for you, either an employee or an outside service. Have them look at it. Kind of a key problem that a lot of dealers will hide behind, and the same on this Lollipop One ad article, was, well, it was pushed by the manufacturer and we don't have control of that. That's not within our control. That's not entirely true. If the manufacturer's pushing a disclaimer that's inaccurate, you can add on to the back of it. You can add on to the bottom of it, right? After the manufacturer's disclaimer, you can put whatever language that's necessary to clarify it and say, or change it. And sometimes some website providers will let you change it, some won't. Some will say that's just the way it is because that's how the feed comes in. I'm sure you hear all this in your business. All the feeds are coming in and you can't change them. But in this case, you can add additional language to clarify whatever is the problem with the disclaimer language.
Okay.
Does that make sense?
That does make sense. Yes. Now, coming from, of course, I'm not an expert here. Is litigation really prevalent, or I mean, is it dumb luck for dealers that maybe most consumers aren't aware of these things and don't litigate? Like what like, because I don't see news articles about dealers being sued, like, ever. So one, is litigation a lot more prevalent than what dealers realize? And then secondly, if it's not, it seems like there's the potential for there to be a lot of litigation potentially.
Right. So there's a lot of litigation. Some of it isn't traditional litigation, but I know, for example, there was a dealer in, if I remember correctly, in New Mexico that was shut down by the Federal Trade Commission, shut down over false advertising. There was a dealer, Bronx Honda, was recently fined, if I remember correctly, it was about $1.6 million for false advertising. And as a part of that, they had to enter an agreement where the Federal Trade Commission was going to review all of their advertising material before it could be published for 20 years.
Oh.
So imagine the government managing your advertising. That's what Bronx Honda has now.
Wow.
And that's not unusual. That's happened plenty of times before. And you can Google, the FTC dealership advertising violations, and some of these things will come up. But typically, the way that problems start is disgruntled customers. And disgruntled customers, I was talking to a client the other day, and I found on one of the review sites, it was Dealer Rater, or it might have been a Google review, I don't quite remember. One of the disgruntled customers said, if you have been upset by, he used a different word, if you've been upset by this dealership, please email me at this address. And so he's trying to stir up a class action, right? More than one consumer going after a dealership because of a violation. So these problems sometimes start with advertising violations, but by the time the lawyers or the regulators get a hold of it, it morphs into something much bigger. It doesn't end up being just the advertising violation, right? The advertising violation is indicative of a bait and switch or a deceptive act or fraud. And when the dealership gets sued, the dealership gets sued for, $500,000 to $1.5 million for all these different violations of which the lawyers are good at coming up with. And so an advertising violation all of a sudden becomes this big thing. So it starts out as something small, but the consumer feels taken advantage of. And as a result of that, the consumer goes to a lawyer, or they might, write the Consumer Financial Protection Bureau. And if they get enough complaints, they're going to come knocking at your door too. With the Biden administration just announced last week that the Consumer Financial Protection Bureau is now hiring additional lawyers.
Okay.
So what are they going to do?
Yeah. Before they get hit with like $1 million fine or, government oversight of their advertising, are there steps that dealers can take? Like the complaint gets lodged. Are there like mitigation things that they can, like steps they can take before it gets to that point? Or is it like, it's a hard line, FTC comes in and boom, stamps you with that major penalty?
I've not heard of it going from 0 to 100. That's generally not how things evolve. Sometimes I've heard of things, for example, happening with a consumer knows somebody who's in the state legislature, and the state legislature calls somebody at the motor vehicle dealer board, and the motor vehicle dealer board starts investigating, and they bring up the dealership under charges, and then that doesn't get resolved quickly, and it gets blown out of proportion, and all of a sudden the politician has to look good for the consumer, right, against the big bad car dealer. And so the politician puts pressure on the motor vehicle dealer board to make that dealer pay, so to speak, and not just pay the consumer, but pay because he's a big bad boy. So I'm going to say 90% of the time, it all starts with, I'm going to say, managing your online reputation, number one, and number two, having a way, and that term is very overused, online reputation. I like to use the word reputation mitigation because you're trying to get a hold of the customer and solve their problem. If you don't have a way to get a hold of the customer and solve their problem, then you really are going to have bigger problems. So step one is solve the customer problems, because usually they can be solved for very inexpensively. and don't get too caught up in whether you as the dealer did anything wrong. I hear all the time, but we didn't do anything wrong. Doesn't matter. I mean, honestly, it doesn't matter. You've got to resolve the customer problem, or they're going to escalate it, or they may go away. I mean, there are lots of customers who just will write a bad review and go away, and that'll be the end of it. But the real key is resolving that, because just as we were talking about class actions a few minutes ago, I know of one class action that started from two ladies sitting in church together. Okay. And they said, "Did you get screwed by the dealer?" "I got screwed. Let's do something about it." And that was, it cost the dealer millions of dollars to get that resolved. So having a good strategy, having good policies and procedures, and having someone at the dealership who can resolve those problems and has the authority to resolve those problems, that's where it starts.
Okay. Makes sense, because complaints aren't the only way a dealer or customer can manipulate a dealer's reputation. Like you said, there's plenty of review sites. Google My Business being a huge one for a dealer's presence. So what's the best way to respond to just like these sort of negative reviews? What's the best approach to like hopefully de-escalate before they pursue the lawyer or lodge the CFPB complaint?
Right. So I advocate checking 36 websites a month. Now, some of them can be checked once a month, but the big ones: Yelp, Google, Facebook, Dealer Rater, My 3 Cents, PissedConsumer.com. Those should be checked on a daily basis by someone. Usually, 9 times out of 10, you can figure out who's posting, even if the name on it is Beach Boy 122. If you make enough phone calls, they say, "I came in on a new car and they wouldn't sell it to me." You call the new car manager and you say, "Look in your logs, who came in, looking at a Malibu, a red one." You have to take the details and you have to do a little Sherlock Holmesing, right, and figure out who the customer was. You pick up the phone and call the customer and say, "Hey, this is so-and-so at the dealership. I understand. How was your experience?" And then if they tell you the same story that's posted on the website, you've got your consumer. But assuming you can't figure out who it is, which really is a rarity, you post something that's not defensive. The internet is not meant, best practices are not going through and putting your whole side of the story. That's not going to help you. You put something like, "I'd like to help you. Please call me. I'm sorry we fell down on the job. We value our reputation and want to make sure you're happy. So please call me so I can make you happy." And, 7 out of 10 times they call and they say, "I'm not happy," and then you fix the problem. Once you fix the problem, which may take a week or 2 or 3, depending on the complexity, at the very end, you ask the customer to, and these words are important, to update their review, reflecting the fact that, we're not such bad guys after all. You don't want to ask them to change their review, because then they feel manipulated. Then they feel like the only reason you reached out to help them is because they posted a bad review. And then you've gone, all the work you put in then goes to sour grapes, and they get upset again.
Okay, makes sense. Yeah, no, I like that a lot. Yeah, it's the idea of, it's universally true with all aspects of dealership operations, just like that transparency and honesty to break that stigma. It doesn't seem like you have alternative designs to what ends you're trying to contact them or resolve something.
Right.
So there are, so many state regulations and different things and different legislation from state to state. But is there where can dealers find resources to understand whether it's national regulations or even their own state regulations for compliance in advertising? I imagine there's some differences and nuances. So are there some simple resources they can refer to just to get some even high level information?
Sure. The FTC website is where I would tell them to start first. There's a whole thing about automotive advertising. I believe it's 40 odd pages. If I don't remember, I've looked at it recently, but couldn't tell you how, but it's long and it's involved. So that's certainly one place I'd look. And then I'd go to and make sure that dealers are reviewing the Motor Vehicle Dealer Board website in your state or their newsletter. They're more than happy to tell you what the rules and regulations are. And it's important, I think, for dealers to have a good relationship with the Motor Vehicle Dealer Board by calling them and saying, hey, I want to make sure I'm doing it right. Can I come visit you? Can you show me what other, a lot of states will have open files so you can go look at everybody's violations. I mean, okay. Part of the Freedom of Information Act, you can go there, of course, not in COVID days now, but when before and after COVID, you could go in and, for example, in Virginia, I could go pull any dealer's folder I wanted and look at it and see what their violations are. So being a student of it and showing that you're interested will go a long way with a regulator. And they want to help you because they don't want to have complaints, because when they get complaints, they then have to fix them. They have to call you or they have to write you a letter, and it's they want to stay out of that loop. So they want you to fix your problems and they want you to be accountable for them.
Okay. Now, thinking of violations, from what I've read and heard, I mean, there's just, so many, like a vast variety of types of violations and consequences and penalties that come with them. Such as I've read there's an issue regarding safety inspection claims to used vehicles, which I don't even know what that means. If you want to explain that, you can, but what are some other significant FTC regulations that dealers need to really be aware of?
Well, there are so many, Dane. I think that dealers should start by making sure the consumers are happy. That's where you've got problems come really on 2 feet. They either come from customers or they come from employees. Those are the first 2 places the problems start. And the third is advertising. Those are the bulk of where most of the problems are going to come from a dealer, from a regulatory perspective, right? An employee feels like you didn't treat them fairly, so they go to the EEOC or they go to a lawyer. So you're going to have to deal with that type of problem. So what's in your employee guidebook? What does it say that an employee should do if they have a problem? Do you have an open door policy as the dealer, where if they're not comfortable with something their manager said, the employee can make an appointment and come see you? All these kinds of rules and policies are important to have, and they're important to distribute so that a disgruntled employee has a place to go in order to try to get their problem resolved. Because I can assure you, if you have an upset employee, they're not going to be productive. They're not going to represent you well. And the problem's going to fester, and it's going to become a bigger problem. There's a expression in claims that says your first loss is your best loss. And what that means is, once you identify a problem, the amount of money you spend on that problem right then and there is going to be the least expensive way for you to get out of the problem, whatever that problem is. If you leave it alone, it could go away. A lot of dealerships say, until it blows up, I'm just not going to worry about it. And that's one way of doing it. That's not what I would advocate. That's not the risk mitigation protocols I would put in place. I would put in place to make sure that employee has a hotline to call, or a consultant to call, or the dealer to call, or however you want to set it up, whatever you're comfortable with. Some dealers aren't comfortable with dealing with some of these complicated issues. And so you can use a third party, you can use an attorney, you can use a consultant, whatever, but there should be some path that's clear and that's communicated, both from an employee perspective as well as a consumer perspective. What your documents say about what a consumer does if they have a problem is very important.
Okay. And I've noticed a trend that whenever I talk to smart people, they usually answer the questions ahead of that I didn't even ask yet. Because one of my questions was, what are some general resolution options dealers have when managing a violation? it sounds like it's not always an attorney. It sounds like you can bring in a consultant. Like, what are there other options or alternatives that dealers can, or tools that dealers can leverage to help come to a resolution for these different issues?
It's a great question. The best way, in my opinion, to resolve these kinds of things is put something in your documents that says that as a condition prior to filing a lawsuit, that the customer or the employee agree to meet with the dealer himself or his representative. His representative could be a consultant like me or a lawyer or whatever he's comfortable with. But that way, the dealer gets a bite of the apple before it becomes a big problem. And if the dealer goes before the judge, let's say you get a lawsuit and the employee or the customer never came to see the dealer, then the dealer files a motion that says, hey, judge, we'd like you to compel the plaintiff to come meet with me because I'd like to try to resolve it. And judges, what are they going to say? No, we don't want you to resolve it. Judges can say, well, gosh, Mr. Lawyer, can't you and your client go meet with Mr. Kline over there and see if you can get these things resolved? He'd like to sit down and meet with you. Is there a problem with that? And if the lawyer says, well, I don't want to do that, it makes the lawyer look bad, right? I don't want to go meet with Mr. Kline. And why would I want to meet with Mr. Kline? What can he do for me? So it's not just some dealers like to advocate, arbitration and mediation and all these other kinds of formalized things. I prefer just kind of a very informal, why don't you come meet with the dealer and see if you can resolve that? If the dealer can't resolve it, then you can always argue. There's always time to argue, Dane, right?
Yeah.
Everybody, you can always argue about everything. But if we're trying to get it resolved, you try to go see the dealer and try to have him resolve it. And again, it should say his dealer or his designee, and that designee can be anyone who he chooses to. It could be a CSI person, it could be a consultant, it could be a lawyer, it could be his wife, it could be whoever wants to handle that, who has a good touch with another person.
I like the idea of less formalized, because you think if you have like this formal process and like it feels almost defensive and intimidating to go sit with lawyers and like, whereas like you're saying, like if you make it a little more informal, it could maybe create a little more a comfort, and even again going back to the idea of trust, that the dealer's trusting you and you can trust the dealer to kind of resolve this without having to get so sort of ugly. Now, I'm going to bring this full circle here now. I want to go back to the first question about that experience you had with that dealer. So with that experience you had with that dealership, with that $679 per month, if you were Tom Kline, the consultant, and not Tom Kline, the buyer in this instance, and that company levied a complaint against the dealer, what are you, as the consultant, what are you coming in to do? What are your first steps to help the dealer resolve this before it gets taken to court or too serious?
Simple. You lease the vehicle to the Tom Kline for $679 a month, and whatever that cost you, it cost you.
That's nice and simple.
It's not this is not complicated, right? I mean, they advertised it. It was false. If you go to court, it can be, $50,000 to $250,000. Of course, you could turn it over to your insurance company, and that's certainly a way to go, and have the insurance company pay for it. But then you've got a balancing act of your premiums, the following year or 3 years hence. So there's a calculation that the dealer has to do and say, okay, is it worth this $5,000 for the mistake that we made? And I'm going to advocate, yes, your first loss is always going to be your best loss. Or you turn it over to your insurance company, and the insurance company is going to mess with it for some period of time and pay that customer out and get them straight. The customer is going to be angry and bitter about having to go through the insurance company and get dragged through that process. If it's a big enough problem, sometimes you can get the insurance company to empower the dealer with a claim to try to resolve that problem. That happens a lot. when you have good communication with your insurance company. So it's just a matter of you as the dealer have to decide how much are you willing to pay and when are you willing to pay? Are you willing to take the risk that this is going to be a big nothing? Or are you, and if so, then good riddance to the Tom Kline $679 a month problem. Or are you gonna make it right and do what's right and move on?
Great. Yeah. So I mean, like there's so many topics you and I could discuss. You sent over so much material to me. Like I told you in our private communications, I'm like, there's just so much that I think there's such a good perspective to potentially, turn this into multiple conversations. So what I want to do is just to give people a better perspective of who you are and what you do. And because, like I said, you're the first Tom Kline I've met. Tom Kline. I mean, you're the first person really that I've seen vocal and active talking about these things. So tell us about Better Vantage Point. Like what is it? What all is it that you can help dealers with?
Sure. This is my shameless plug part, right?
This is it. I mean, you've provided the value. Now let's talk about how else you can help dealers.
There you go. So I do three things, Dane, briefly, and I like to think of it as three legs of a stool. So the first is dispute resolution. And we talked about dispute resolution really starts with the online reputation. How do you handle those customers? If you don't want to handle the customers, you can third party them out to me and I'll handle them for you, depending on the size of your dealership and whether you want to mess with them or not. I had a dealer who I know of recently, which this is sad and terrible, but he sold his 3 dealerships because he just didn't want to deal with the consumer problems anymore. He just didn't. I got to him too late. Otherwise, he could have sent them all to me. So it starts with reputation management or reputation mitigation, making sure those online complaints get handled, they get resolved, and so that you don't have disputes with employees. You don't have, as we talked about a few minutes ago. So that's kind of one leg of the stool. Second leg of the stool is compliance, which is are you following all the policies and procedures? And there are too many to enumerate here. But part of that is, are you training your employees on a weekly or bi-weekly basis? And best practice is you train them on one compliance topic and then have them sign a sheet that they've been trained and they understand, and that goes in their personnel file. So that when a regulator walks in and says, well, you're not doing ABC correctly, you go to one of the employee files and you pull out these 52 pages, because that employee's been here for 2 years, right? 26 times 2 is 52, right? You pull out and say, okay, well, we may be wrong, and you can crucify us that we're wrong, but here's where we trained on this topic, and here's where we trained on this topic, and here's where we trained on this topic, and this topic, and this topic. We're trying to comply. You're never going to get it 100% right. It's just not possible. There's just too many laws and too many rules. But if you're training your employees every 2 weeks or so and having a sign off, then that's best practices, and that will mitigate any damages as a result of any of these regulators coming in: Motor Vehicle Dealer Board, FTC, attorneys general. We haven't talked about the attorneys general and the consumer branches of the state government. Also, there's so many different regulators. It's incredible. I had the Department of Housing and Urban Development was in my office when I was an owner of the dealership. They have their own police force, believe it or not. I've had the Secret Service. I've had all these. Everybody comes into your dealership. So all kinds of regulators. So being in compliance isn't a one-time thing. It's a process. And part of that process is training the employees. And so training is part of it. And then putting the other policies and procedures in place is an ongoing process. And then the third part, the third leg of the stool is risk mitigation, which is, are you putting in the proper policies and procedures, and do you have the right insurance coverages? Some dealers buy the cheapest coverage they can find and call it a day. Well, that's not really the best way to do it. You should be comparing all of the bells and whistles on all of the policies, looking at the retentions or deductibles on those policies, so you can see if you do have a problem, and we play all kinds of what if games. What if this happened and what if that happened? Does your policy cover those things so that the dealer principal knows where the chinks in the armor are? He knows that he's covered for these things, but he's not covered on those things. Then you can have discussions about, okay, how can we cover these perils? How can we fill in the gaps, or what can we do from a policy perspective to make sure that those things don't happen? So anytime you pull away any of those legs of the stool's going to fall over, because this is the back end of your business, and it's important to pay attention to that. Selling cars is fabulous, and we want to make sure you sell all the cars you can, but my job is to kind of protect the dealer's backside with those three legs of the stool.
And that's why I thought that talking to you could be broken up into multiple episodes, because that is, I mean, just that is a lot that dealers are managing. So thank you for that perspective. And like I said, we're definitely going to dive into some more stuff at some point in the near future. But before I let you go, this season, I am playing a little vernacular game with guests, because I was born and raised in Pittsburgh, Pennsylvania.
Okay.
Where we have unique terminology and a way of pronouncing words. So here's how this is going to work. I got 2 words for you. I'm going to say a word. You take a guess at what it is. If you're so confused that you don't even want to take a guess, I'll use it in a sentence to see if that clarifies it. Does it make sense?
Okay.
All right. So first term, gum band.
Try it in a sentence.
Hey, can you reach in the desk and grab me a gum band?
A rubber band?
A rubber band. That's it. That's in Pittsburgh. In Pittsburgh, for whatever reason, we call it a gum band.
Okay. I never heard it before.
This one, it's outside. It's used outside of Pittsburgh, but it's not used everywhere.
Okay.
The word is hoagie.
Oh, it's a sub or a sandwich, a long sandwich. Yes.
That's it. All right. So at least hoagie, it's not so unique or exclusive to Pittsburgh.
No. I went to school in Connecticut, and they had hoagies in Connecticut.
Fantastic. Well, Tom, I thank you so much for joining me today on the KPICafe. You really brought a comprehensive perspective on a brand new issue that I've not previously discussed, and I have absolutely no room for even trying to talk about it besides asking questions about it. So I thank you for that.
Thank you for having me. I think you don't give yourself enough credit, but I appreciate what you're saying.
Absolutely. And Tom, if dealers who have listened want to get in contact with you because they need a consultant or they want more information, how can they reach out to you?
Best thing is you can go to my website, which is bettervantagepoint.com, or just call me on my cell phone, 757-434-7656.
Great. All right, folks, you got it. You know how to reach out to them. Again, thank you, Tom, and everyone, thank you for listening in. Next week, we have Robert Sneed of Power Ford to talk about how his focus on people, process, and product is yielding success. As always, don't forget to subscribe to the KPICafe on your favorite podcast platform, as well as on our YouTube channel to never miss an insight. Tom, thank you. Everyone, thank you. And I will talk to you next week.
Thanks, Dane.